The court will now move to the consideration of our next case, Alcegaire versus the state of Florida. Counsel?
Yes, good morning, Mr. Chief Justice. May it please the court. Alice Kopek, Special Assistant Public Defender on behalf of Johnathan Alcegaire. The foundation of this case was Mr. Campos. That is what, he was the surviving victim to the crime and the sole eyewitness. That's what the prosecution repeatedly argued to the jury below, and that's what the state implicitly is arguing to this court when it repeatedly cites to Mr. Campos' testimony and identification combined with circumstantial evidence putting Mr. Alcegaire in the vicinity. What's striking in this case is nowhere in the answer brief do we see that character, that what we routinely see, that overwhelming evidence of guilt. That overwhelming evidence of guilt requires affirmance. It wasn't advanced in the answer brief. It wasn't, there was no articulation of overwhelming evidence of guilt. And I submit that it's because they can't. We know that the trial judge characterized that any evidence regarding Mr. Alcegaire's actual possession or discharge of the firearm was weak and speculative at best. We know that the jury's sentencing verdict did not find that Mr. Alcegaire actually killed anybody. We know that the state concedes in their answer brief that the prosecution repeatedly argued facts not in evidence, facts that weren't strictly supported by the evidence, that they engaged in embellishment and hyperbole, and that they offered personal opinions as to the facts in Mr. Alcegaire's guilt. And then they go on to cite that even though it's not supported by the evidence or not in evidence, well, that possibly be true, or it could have happened. Equally, it could be not true and could not have happened. And we know that convictions can't be based on probabilities. So it certainly can't be based on mere possibility, speculation, innuendo. You know, the only evidence that placed Mr. Alcegaire at the scene of the crime was Mr. Campos. And he said he knew it, was Mr. Alcegaire because he saw him, he walked into his room, he looked him in the face and knew it was him. Now we know that that's simply not true. Now there's 5 issues, critical issues that I've raised in this brief.
Well, the record is clear that there's evidence to support the fact that the defendant here was driving the rental truck from Miami to Lakeland. Isn't that correct?
That is correct, Your Honor, yes.
And let me ask you this. Is there any, we have a timeline about how much time that truck was in the vicinity of the scene of the murders. You know, when it went in there and when it went into that particular neighborhood and when it left that particular neighborhood. Isn't that correct?
We do. I could find out on rebuttal the exact time. I can't remember the exact time, but there was surveillance that showed the van go by near the crime scene and then leaving the crime scene. That's correct.
And we know when the van left Miami.
Correct.
And we know when the van got back to Miami.
Yes, sir.
And we know that there wasn't much time. So how do you, it seems like there's just overwhelming circumstantial evidence that he was in that truck and that truck went to that spot and there was so little time to go anywhere else. How do you respond to that?
Well, Your Honor, and I think I'll jump a little bit and hopefully not get too off track, but I think that's what goes to the Giglio argument that I raised. And certainly that there is circumstantial evidence, and that's what the state argues in their answer brief, circumstantial evidence to put him in the van and in the vicinity in Lakeland. And then that's what becomes critical is that when the state argued in rebuttal without having the defense be able to argue and respond to it, that there was no way he could have been at the alternative scene that the defendant was positing, I was at West Magnolia and not East Magnolia, there was only a 6-minute, to get from one scene, the crime scene, to that West Magnolia, there was only a matter of minutes. And if I recall correctly, it took them longer to get down to my...
You're saying it's only 6 minutes from the East Magnolia address to the West Magnolia address. So was there evidence? What evidence supports that?
I'm sorry?
What evidence supports that 6 minutes?
Okay, so, and I'm not even saying from one street, I'm saying actually from that address to the West Magnolia, specifically the address, when you track the surveillance cameras and the time. So for instance, and I might have the time wrong, but at 6:41, the surveillance camera tracked it by the liquor store. At 6:43, it tracked it at another, I believe, in another store. And then it tracked it at a toll booth. So when you look, I'm sorry?
The last place you said it tracked it, what was that?
That was, and I'm sorry, not a toll booth, a red light camera. And when you look at the map that is on deposit with this court,
that's the Lakeland Hills Boulevard camera, right?
Correct. And when you look at the map and you do even just a visual, so that's perhaps 3 to 4 minutes, and I want to say about 3.
But that's
based on the camera.
That's totally your speculation. The
no,
time,
Your Honor.
Your speculation, right?
No, I would argue, Honor, it's not speculation. That's what the evidence shows. And they put in what the times were. And then when you look at the map that the state used in rebuttal to say it was impossible, that the map clearly shows that the 2031 West Magnolia address is actually closer to the red light camera. And it passed right directly by the 2031. So it would only, I believe that evidence clearly shows that it totally was a reasonable hypothesis that he actually, yes, he was in Lakeland, and that could be considered the vicinity, but it certainly within those timeframes could be that they stopped off at another residence address.
There was also the surveillance footage showing Mr. Alcegaire wearing a straw hat while driving the U-Haul van, both at the Monte Carlo apartments and while driving the U-Haul van. And the same van that he was seen by Campos driving with Smith in the van with him. Those were additional factors.
Yes, correct, Your Honor. There is no dispute in the fact that Mr. Alcegaire was in the van and that Mr. Alcegaire was in Lakeland.
And also in the van with Smith.
Dispute that. I'm sorry?
Do you agree that he was also seen in the van with Smith by Campos?
He was. Well, no, not by Campos. He was seen in the van. Mr. Campos saw Mr. Smith, but he didn't see him in the van. And that goes to our motion for new trial. We know that the single critical piece of evidence that Mr. Campos saw Mr. Alcegaire that day is false. It's fundamentally flawed, and it subsequently crumbles. And so that becomes the issue. Yes, he traveled to Miami, and that is a circumstance, but the evidence aligns with the fact that this alternative address that he could have been at, the evidence completely aligns up with that. And that's why we go into the Giglio argument of why that was so fundamentally erroneous, that she knew it was false, that she argued it anyway. The objection was for her not to use it, and specifically objected she's introducing evidence in rebuttal.
But
and we know
about the whole thing about the West Magnolia address and the possibility that the defendant was there, there is absolutely no evidence that supports the presence of the defendant at that address. The only thing that even brings that address into the picture is that at some point he searched for that address on the internet. Isn't that correct?
Yes, that's correct, Your Honor, but I would, not at the risk of sound, I don't want to be meaning or anything, but obviously Mr. Alcegaire he doesn't have any burden to prove.
I understand that.
So, I mean, certainly what it was, I'm sorry.
Wait, but okay, so there are a million other places in Lakeland he could have been. I mean,
Well,
why not pick one of those? I mean,
well, but that's the thing. I mean, it wasn't completely out of the blue or speculation. I mean, there was evidence that he searched and mapped that address. So that is the nexus to be able to say that it is reasonable that he, in fact, went to 2031 West Magnolia. So it's not speculative to just pick an address. But I think where we go is that with the 5 essential issues that I've raised, they can't be looked at in isolation. When this court's looking to whether reversible error occurred, whether absent this error, the jury would have convicted anyway, it can't be analyzed without acknowledging that that single critical piece of evidence was flawed and subsequently fell post-trial. To ask, well, what would the jury think of this if they knew that Felix Campos did not see Mr. Alcegaire? And that's why I submit that the motion for new trial, based on the motion and the record and the briefing before this court, on its face should have been granted. It's interesting. I think it's clear that we focus on those interviews. The focus of it were on Tavares Mack. Mr. Mack was set for trial the month after that. So under probing questioning by the prosecutors, his certainty 1 week was one thing, and then under more intense probity the following week, he waffled, backed off. Well, Mr. Alcegaire, and the focus wasn't on Mr. Alcegaire, they already had secured their conviction on him. But those questions and those post-trial statements should also be subjected to intense scrutiny. It should be subjected to the crucible of adversarial testing. And perhaps they would also fall. But even if they didn't, there is a significant material difference between the jury hearing by their first witness and right after opening statement that I saw Mr. Alcegaire and I know it was him because I looked him in the face, versus knowing he never saw him and that he says he knew it was Tavares Mack because of his voice, but he can't say any substantive conversations, and then later says, no, I don't know it was. And so I think that is why I would submit on its face and the record you have that the motion for new trial should be granted, but at the very least that there should be an evidentiary hearing to subject those statements to the crucible of adversarial testing. And I think just to go back quickly on,
let me ask you about the motion for new trial. Maybe I'm missing something here, but I'm struggling to see how the trial court had jurisdiction to consider that motion after the notice of appeal had been filed. That is generally the case, I believe, that when a notice of appeal is filed, that's it. Absent for some technical things related to the perfection of the record, the trial court is divested of jurisdiction. The trial can't do anything that would affect the order or the judgment and sentence in this case that was the subject of the notice of appeal. So why would that be different here? I don't understand how that general principle is not applicable here. Help me overlooking.
And Your Honor, and the quandary that we get in is, and I think generally that would be correct. And then we get into, well, then we could move to relinquish jurisdiction and direct the court, give us a ruling on the merits. But what the court did here is, I don't have jurisdiction, but based on the precedent of this court, and that's what he relied on to say, but motions based on newly discovered evidence should be.
That precedent is in totally different factual circumstance, isn't it?
Well, right, but the quandary that I was in was we have a ruling on the merits. So
well, if you got a ruling on the merits from a court that didn't have jurisdiction, you don't have much.
Well, and I think the precedent of that court was all about judicial economy. That was the understanding of it. It's judicial economy. It certainly would be raised in a 3851 down the road if we have to get there.
Well, I mean, I think it's a general principle that the desire for judicial economy would not vest a court lacking jurisdiction with jurisdiction. But I belabor the point. I'll see.
Right, and I just want to stress that had the issue been that he just recognized I don't have jurisdiction and denied it, then we would have been filing for a motion to relinquish jurisdiction, but we had a ruling. And then what I said, that's for a later day, but it was certainly going to be an issue on 3851 because it's inexplicable that trial counsel waited till after the notice of appeal. I mean, he was on notice. Mr. Alcegaire tried to seek relief for 3850. The court denied it as a pro se nullity. Trial counsel was given a copy of that. That was a few days before sentencing. And I understand if you wanted to wait till after sentencing to trigger that 10-day period within sentencing, I could understand that. But to then wait until after the notice of appeal filed, I mean, that'll be an issue down the road for a 3851. But as I said, I mean, we would have been in a different posture if the judge had literally just said, I have no jurisdiction. And I think, obviously, I believe that this court can relinquish jurisdiction all the way up until an opinion is issued. Now, I asked for that relief in the reply brief, if that was necessary. If I need to file a formal motion, I mean, I could do that. But that was the quandary that I was in, was that we did have a ruling on the merits. And I argued that it was erroneous, and particularly that some summarily deny it. And I do want to note with the argument whether when he cited the wrong, was it 3600 to A3 or 3600 B8 under the catch-all, the courts routinely, I shouldn't say routinely, there's not a whole lot of cases, but they often look at those issues in tandem. I know I cited State v. Dunaway in my brief where they said it could be sustained under either one of those rules. And then there's another case that I don't think I cited, it's State v. Coyne. It's a Second Circuit case, 512 Southern 2nd 221, where they filed under the newly discovered evidence of 3600, and the court said no, but I'm going to look at it under the fair and impartial catch-all and granted it on that. But if I go back to, when I say that we can't look at these issues in isolation, they have to be analyzed with all of the other issues, particularly what we know post-trial. And as I mentioned, like with the Giglio claim, the fact that the state in its answer brief said there was nothing in the record to show it's inherently false, but then it goes on to state the fact that if you look at the facts and the map that's on reposit with this court, it is fundamentally false. And I believe when they're saying, well, it actually helped Mr. Alcegaire's defense, well, again, they waited till rebuttal and he never had a chance to address that. But I believe that goes to the materiality prong. And of course, if we satisfy that it was false and knowingly false and material, that it could lead to a reasonable possibility of acquittal, then the burden is on the state to prove that it's harmless beyond a reasonable doubt. And again, I don't think you can look at it in isolation without, well, if the jury knew that van passed right by the house that Mr. Alcegaire claimed, and that Mr. Campos never actually saw him, then that leads to a reasonable doubt of whether he was actually in whether it was in that home. I do want to, in threading it, as I mentioned before, the state had conceded in its answer brief that there were numerous improper closing arguments. And I just want to highlight a few. One of them is that the conversation that provide.
back because I'm trying to digest something you said that about the van going right by, if I understood you correctly, the West Magnolia address. Is that what you said?
Well, right.
What is there in the record that supports that the van went right by the West Magnolia address, or even went any closer to it than Lakeland Hills Boulevard?
Well, I mean, what they testified to was that it went by the Lakeland Hills Boulevard on the way to I-4. And when you look at the map, and I'm not saying that there was evidence that it traveled directly past that address. What I'm saying is it traveled directly past West Magnolia. And when you look at the map, 2031 is right by, I think it's Highway 92 and West Magnolia. And they were traveling, and it's right near I-4. So what the officer was saying, testified to, was they traveled west on 92 to I-4. Does that answer your question?
Yes.
Did I answer it? Okay.
Well, but I don't understand how you get from that to saying it went right by there, because you have it no further down that road than a spot that I think what we have before us would show is some distance from the vicinity of West Magnolia.
Well, Your Honor, and what I would maintain is the only evidence that you have for that is the state's argument. Because and that was my issue, is when you look at the evidence that was presented and you look at the map and diagram that she used, then it becomes clear she argues it's way on the opposite side of Lakeland, and there's no way they would have traveled that way to go to Miami. But we know, in fact, that they did. And when you track,
how do you, but again, I'm just mystified by the argument that you say you know that they did. How could you know that they did? There's a reality. When an interstate goes through a city, there are frequently many different ways to get from a particular spot in the city to the interstate. And you're just assuming a lot here that it seems to me there's nothing to support in this record.
Okay, and Your Honor, with all due respect, like I said, if we track, and that I think is one of the problems when the state says, well, it can't prejudice Mr. Alcegaire because it actually helped his defense. It helped his defense if he would have been able to point that out. I think your questioning shows that how convoluted the testimony was and how difficult it was to be able to track the surveillance and track the van moving down to show that it traveled at least within minutes of that 2031. That's undisputed. That toll booth is within minutes of 6031. Just to briefly highlight some of the, and forgive my question, the time that I have on doesn't include rebuttal, is that correct?
It does include rebuttal, I believe.
On some of the numerous improper closing arguments, I want to highlight a few. That the conversation about providing a nexus to Mr. Joseph that is nowhere in the record, and it was the only evidence to try and tie that motive and the intent of why they were there. There was no other evidence, so that was particularly egregious because, as the state concedes, that evidence wasn't there. It created a hypothetical dialogue that this jury never heard. The opinion that she provided, her personal opinion as to the fact and Mr. Alcegaire's guilt, the state says, well, she did provide her opinion, but it was based on reasonable inference. Well, there's no exception in the case law that forbids personal opinion to say, well, it's okay if you can infer it from the facts. I mean, it's a categorical bar to expressing a personal opinion. The argument about the characterization of Mr. Smith and Mr. Alcegaire in the elevator, state wants to say, well, it's just hyperbole. I mean, first off, to start, whether hyperbole,
Counsel,
particularly in a death.
Counsel, you are now in your rebuttal time. You may keep going,
Okay.
but I want to let you know that you're in it.
Okay, thank you so much, Your Honor. Whether hyperbole is even proper, particularly in a death penalty case, but the state then omits the reason why she was talking about falsely that they were high-fiving and whooping. And that was because it showed that they were excited to go kill people and happy to go murder people.
But wait a minute. But they were. There was evidence of that. The audio-less surveillance video in the elevator showed Mr. Alcegaire and Mr. Smith basically slapping their palms together multiple times, did a hand gestures and shook hands. They were smiling, and it looked to me, I mean, when I description of it, it looks like they were pumping themselves up. This is right before they left to supposedly commit the crime. So there was some celebration. It may not have been the high five that we're accustomed to seeing from athletes after they scored a point or something, raising their hand completely up and slapping their hands. But there was some of that going on. So he may have overstated it, but there was some celebration going on, wasn't there?
Well, and right, I would say that the state argued it was mere hyperbole or embellishment, but if it was embellishment, it was egregious embellishment, particularly when she then characterized that what they were doing when they were conversing and slapping hands or whatever it was, that was egregious hyperbole and embellishment. And then the justice for the victims argument, obviously that's been condemned by this court for decades as totally antithetical to guarantee a fair and just trial, and particularly when you're talking about a death penalty case. I believe it makes it even particularly egregious. And I will reserve the rest of my time for rebuttal unless there's any other questions.
Counsel, you need to unmute.
Thank you, Your Honor. May it please the court, Timothy Freeland here on behalf of the state of Florida. I'm going to proceed, with the court's permission, I'm going to proceed through the issues in the order in which they are presented.
Mr. Freeland, you're going to need to speak up a little bit. I, for one, am having a little trouble hearing you.
Oh, I apologize, Your Honor. I'll see if I can lean forward and hopefully the microphone will pick me up. Is that any better?
Marginally.
Marginally. Okay. Well, I've got a theater voice I can use, so I'll go ahead and do that. Number one, what I'd like to do for the court is to go through the issues in order as they're presented in the briefs, and I'll start with issue number one. The issue here is whether or not the lower court had any jurisdiction to address a motion for a new trial, and I think the court has correctly identified the rule, which Florida Rule of Appellate Procedure Rule 9.600 to divest the lower court of any jurisdiction to rule on this type of motion. So I think that I understand my opponent's quandary about whether to ask the court to relinquish jurisdiction so the lower court could review this now. But I think that if this court were to merely affirm the lower court's finding that it did not have jurisdiction to rule, they would not be in any worse position. They could then address this when the court clearly has jurisdiction in a Rule 3.851 motion, if they chose to advance this then.
Let me ask you this question. And again, my understanding of law is that once one files a notice of appeal, it divests the trial court of jurisdiction and now it's in the hands of the district court or the Supreme Court. However, there are some conflicting rules in Rule 3.590 of the criminal rules provides that allows the filing of a motion for a new trial in death cases within 10 days after the written final judgment of conviction and sentence. If that is the case, then they had until like March 18th in which to file this. They have plenty of time to file it. Now, are you saying that the mere filing of the notice of appeal supersedes all this? Once they do that, then it's over as far as the trial court is concerned.
But that's my understanding of how the rule works, Your Honor. The rule 9.600 severely restricts the kind of rulings that the lower court can make once a notice of appeal has been filed. And like I said, if the court affirms that the lower court does not have jurisdiction to rule, the court, once this case is over and the mandate is issued, the lower court could then proceed to address this issue if it chose. And the defense is in no worse position from what I see.
And counsel, isn't it the case that if someone's filed a motion for rehearing that is pending, and then the defendant in the case files a motion for, files a notice of appeal, that would be deemed an abandonment of the motion for rehearing?
Well, that would be my understanding. I don't think once the notice of appeal is filed, I think the lower court.
I mean, so what the things that go on under the rules of criminal procedure, that's there. But once you go to the appellate court, you've left that court. I mean, aside from some kind of housekeeping things with respect to the record.
And also, I think that's something that the lower court could also do something with post-trial release, not in a death case, but the lower court has that kind of jurisdiction.
Well, the 3800 is you've got,
right,
something that's not applicable here.
Correct. So I guess the point would be since they have, the defendant has 30 days in which to file a notice of appeal after the sentence is imposed. Am I correct?
Yes.
So they had plenty of time in which to file a notice of appeal and have this other motion for new trial heard before it was filed. So they rushed to judgment as far as filing a notice of appeal. That's the point.
Right. Yes, I would agree. I think that if they had wanted to, they could have filed the motion for new trial and had it heard before filing the notice of appeal. And it's unfortunate that it turned out the way it did. But there's no harm to the defendant. The same issue can be explored after this appeal is resolved. All right. I would like to move on to the closing argument issues. It's important to remember, of course, that there was no objection to any of the arguments that they are complaining about, that Mr. Alcegaire is complaining about in his initial brief. And so, of course, if we're looking at whether there's fundamental error, we have to examine the cumulative nature of all of the arguments, the allegedly improper arguments on the verdict. I don't see that there is that kind of cumulative impact such that the verdict would not have been obtained but for these arguments. If we start out with the statement about the prosecutor saying to the jury that he heard David, the victim who was killed, saying, I gave the money to Z, or I gave the money to Zoe, I can't dispute that there wasn't any testimony to support that, but we do know that Jamal Smith was beating David with a bar stool, and he had money in his hands that he was counting, which is a reasonable inference. He had just gotten that from David, and then he continued beating him. And then after beating him for a period of time, he then shot him. So it's not that much of a stretch that there was a reason why he continued beating him. I can't dispute that testimony didn't actually come in, but I don't think it's an egregious. I don't think it's fundamental error that statement to have come in. Where's the rest of it? That seems a reasonable. That is reasonable. That's probably the conversation they were having. I wish that the testimony had come in. They would make my argument so much easier. If we move to some of the other arguments, specifically the ones that my opponent outlined. I agree with the court that with regard to the movement in the elevator, the jury saw what was going on in the elevator. They saw all of those videos. There are several videos of them inside the elevator, and I don't see how the prosecutors characterizing it in a certain way is an improper comment on the evidence. We see what was there. She may have exaggerated it slightly, but it's fair comment on what was going on in the elevator. The court has seen the video. I've seen the video. I don't see how that is fundamental error. With regard to the justice for the victims argument, I think that opposing counsel, Mr. Carmichael, who was the trial attorney, effectively dealt with that during his closing argument. I mean, his argument was that he agreed that this was a horrific murder, and that we have 3 people killed execution style, and we have a 4th one that they attempted to kill by shooting in the head. It's not the best argument that the prosecutor should have made. She should not have. We know that that's not the kind of argument she should have made. But in closing, defense counsel said this. Yes, it is horrific. It is egregious. But my client was not there. My client was not responsible for that. So I think that was an effective response to that argument. So those are my arguments with regard to closing. I want to move to the map issue, the rebuttal argument. What's important to notice here is that nobody, not the state or the defense, is arguing that the maps themselves are inaccurate, that there's anything wrong with the way those maps depict the streets and layouts of Lakeland. So that is, if anything, that is the evidence, the map, even though it was not admitted into evidence. It was admitted as a court exhibit. In trying to characterize this as a Giglio claim, I think it's important that we step back and look at what Giglio talks about. And Giglio does not talk about argument. Giglio talks about knowingly presenting false evidence. And what the lawyers say is not evidence. So I don't see how this can possibly be considered a Giglio argument. The map does show that, and I think the state argued that the band that we're talking about moved through 92 heading west, and they argued that they continued on west towards I-4. And I think those maps support that argument. As I indicated, it places the van a little bit closer to the West Magnolia Street address. If the jury was inclined to buy the argument that they dropped off Mr. Alcegaire at that West Magnolia Street address, that map actually assists the defense in trying to establish that argument. Here's the thing.
Let me ask you this, counsel. Is there anything in the record that actually that was evidence concerning the relationship between East Magnolia and West Magnolia? I know, ordinarily you think about East, for instance, East Main Street, West Main Street. You'll think, well, that's one end of it is East and the other end is West. That's not what is the situation here at all, right? I mean,
Correct.
These streets are they're just in different parts of town.
They're
not connected. I mean, obviously there are roads that go between them, but they're just separate. They're separate streets entirely. Correct? That's
correct.
Is there any evidence that? I understand that the demonstrative aid shows that that's mapped. Is there any other evidence in the record that shows the relationship between those streets?
No, there isn't. I didn't see any. So as far as they being 2 separate streets, there isn't. So that demonstrative aid does help the state in making that argument that they are far apart. The 2 streets are far apart. It's not like you can just.
Can I ask you what evidence was there at trial about the West Magnolia address?
I'm not certain of Your Honor's question.
Well,
the evidence.
I'm asking what evidence at trial was there concerning the West Magnolia address? I mean, what was before the jury concerning the West Magnolia address?
There was a map introduced showing the West Magnolia address, similar to this one that we're arguing about, except it focused in expressly on the murder scene, and it shows an overhead of how 92 is related to, I think it's Fairway, and then
that's the East Magnolia. You're talking. The scene of the murder was East Magnolia.
Right. I'm sorry. You're asking.
I'm talking about West Magnolia.
I'm not aware that there was any map other than this one introduced to that.
I'm not asking about a map. I'm asking about any evidence related to the East Magnolia address.
The East Magnolia address evidence was that the defendant looked up that address prior to the murder. It was in his cell phone that they extracted it from the cell phone that they got.
And so the state presented that fact.
Yes.
Or did, okay. That was helpful.
Okay. Thank you, Your Honor. I'm sorry for the.
That's okay.
So my argument then is that, you know, if we remove the map from the equation, which I'm not entirely sure that the defense would want to do that, seeing as how it benefits them, would the prosecutor still be able to make this argument that these are two entirely different streets and that they're far apart? I think clearly, yes, they would still be able to make that argument. So I don't see that there's anything there that needs resolution, particularly in light of the fact that you know, the map itself actually helps the defense, if anything. I'm not going to make any further argument. I've written on the victim impact evidence. My argument stands in the brief. I don't have any additional argument as to that unless the court has some question about it. I would just note that all of the victim impact evidence was reviewed by trial counsel, Mr. Carmichael, and they did not have any objection to the content at the time. The court, of course, needs to address sufficiency and proportionality, but I've also made I hope, a thorough presentation of that in my brief. So if the court has no other questions, that completes my presentation.
Well, thank you, counsel. Rebuttal argument now. Counsel, you need to unmute. We wish to hear your rebuttal.
Thank you, sir. Can you hear me now? I'm trying to get used to the Zoom stuff. What I wanted to emphasize about, you know, the state just mischaracterized what the prosecutor argued about the map and about those representative incident addresses. She did not say that they traveled west past West Magnolia. She specifically said that they wouldn't have traveled west to go to Miami. That is what she argued. I believe Giglio and its progeny says presenting false and misleading characterizations in the narrative of the case is wrong. And the specific objection from the defense was that she essentially
what is there to show that that is false?
Well, again, Your Honor, that's what I said, why it's key to look at the facts that I laid out in my brief of when the surveillance is tracking the van. And then, so we know, and she says it's all the way across town, we know that it's approximately, I mean, I think it's reasonable to say it's approximately 6 minutes when you track that van. And they said they were traveling to I-4. And as I said, I think it took them longer, I might be wrong, to get to the scene than it did coming back. So it would have taken no time to swing by that place. And that's why I argue that it's false. And this whole notion that, well, because it helped the defense, there's no prejudice. Well, I believe that's maybe why she waited until rebuttal to argue this and say, I figured it out personally. I went and did an investigation, and I know I'm short on time. I want to emphasize with the victim impact evidence that I want to stress that was the only evidence that was put forth. And the state, perhaps in just a mistake or a Freudian slip, at the beginning of their argument said the state was required to prove an aggravator to get death, and they did that with 14 victim impact evidence, which of course we know can't be an aggravator. They said that later, so that's why I say it might be a mistake. But I think that highlights the inherent problem with jurors even being instructed that they're not aggravating factors of taking victim impact evidence to say, well, that warrants death. And I think that mistake shows it. I see that I'm about up for time, so I would urge this court to reverse and remand for a new trial, or at the very least to reverse and remand for an evidentiary hearing on the motion for new trial.
Well, thank you, counsel. We thank both of you for your arguments in this case. The court will now stand in recess for about 10 minutes before we take up the last case on today's docket.